Please be seated. The court is now back in session. Once again, the floor is given to Ian Series defense to continue their response to the questions put by the chamber. In fact, question number 5 was actually removed. And it was another question was added, and that you may respond to the last question in the afternoon session.
Very well, Mr. President. Before I go on to the questions, just to point of clarification, because I was told that perhaps some may have been lost in translation, and I failed to cite some of the authorities, just so you have it on the record and for easy access. And because my team worked very hard to organize everything, and I went off script. Concerning Rule 73 bis, I invite your attention to look at the 28 July 2003 version, where under Rule 73 bis D, it says, after having heard the prosecutor, the trial chamber may fix a number of crime sites or incidents comprised in one or more of the charges in respect to which evidence may be presented by the prosecutions, which, and it goes on. So this was the second version of Rule 73 bis. And of course, this seemed to be in conflict with the statute, because the prosecutor is obviously very independent. And then if you look at the latest amended version, which is 28 August 2012, I'm sorry, let's see. Make sure I have it right. My apologies. The first amendment was 17 July 2003, and then the subsequent was amended in 30 May 2006, where it says, after having heard the prosecutor, the trial chamber, in the interest of a fair and expeditious trial, may invite the prosecutor to reduce the number of counts charged in the indictment, and so on. So obviously, this rule is designed to dismiss counts, and because the prosecution has that authority to do so, the trial chamber is inviting the prosecutor to be heard and to initiate any dropping of charges. I made reference to a United Nations report, or a report to the United Nations, and this is to the General Assembly and the Security Council. It's 21 August 2006, wherein, and we can provide it to your honors, wherein it states, trial chambers, this is by the president of the tribunal, who has to report regularly to the Security Council, trial chambers are also proactively expediting trials. Notably, trial chambers are using Rule 73 bis to oblige the prosecution to focus its case. Rule 73 bis allows the trial chamber at the pretrial conference to order the prosecution to limit the presentation of its evidence and to fix the number of crime sites or incidents contained in one or more of the charges, and it goes on. But this is so you can make reference to it, because it's good to know the historical aspects of it. And then, just to highlight a couple of other points, the prosecution made reference of the Stanisic case, the Stanisic and Samatovic case. And if you read that, this is a decision based on Rule 73 bis D, Again, it goes to dropping or reducing the counts in the indictment. Paragraph 7 is very clearly, the trial chamber, 73 bis D, gives the trial chamber discretion to invite the prosecution to make reduction of the crimes of the indictment. So this is the difference in the system. You have no authority, with all due respect, to reduce the closing order. It is what it is. You have other discretionary powers, such as how you will proceed in trying it, but you cannot willy-nilly dismiss that which has been proposed by the prosecution and then investigated, and now you have the closing order. There's this elaborate process. So I point this out, and also since the Mladic case was also mentioned, the decision on consolidation of the prosecution's motion to sever the indictment, where they wanted to take out Srebrenica and try it with the Karadzic case, there is one reference to 73 bis D, but only in the context of reducing the indictment. Nothing about severance. And therefore, it is more like apples and pears when you compare it, not to mention we're dealing with a system that is wholly different. And finally, I had made reference to your honors of a decision that was taken by the Supreme Court on Ingtrit, and I'm referring to E-138/1/10/1/5/7. A lot of slashes. 14 December 2012. And just to make sure that you have this, and my apologies for not being more fluent in my presentation, but in paragraph 37, it states, traditionally, most civil law jurisdictions have adopted the principle of legalism, in parentheses, or otherwise, mandatory prosecution, pursuant to which the prosecution has no discretion to discontinue or ask for the discontinuance of a criminal action once it has been initiated, and the court, which has sole authority to terminate proceedings, can only do it for a reason specifically expressed in the law. Of course, I'm speaking to the converted because you all know the civil law system, and perhaps some Anglo-Saxon judges or lawyers may not appreciate that because they have certain powers to dismiss in the Anglo-Saxon system, but in the civil law system, it's rather clear. And then if you look at paragraph 38, Your Honors, it's the Supreme Court that is saying the cause of extinction of criminal actions are explicitly listed in Article 7 of the CCP and are limited to the death of the accused, the expiry of a statute of limitations, the grant of an immunity, the abrogation of the law, and res judicata. It follows that the court operating under the CCP has no authority, let me underscore that, no authority to order termination for other reasons. And so effectively, going back to what I was saying earlier, were you to adopt the second prong that is being suggested by the Supreme Court, or as an option, in which the prosecution is proposing, at least in the version that they're proposing, in order to have it a quick one, or even in the version that I am proposing and the Nunchia team is proposing, which is you still have to go through the entire closing order, you are still mandated to come up with a plan and to figure out what you're going to do with the rest. You simply cannot just park it. Parking it does not count. And that's not one way to sort of alleviate any pain or discontent to the civil parties by saying, maybe we'll get to it. I think it is rather clear. When you look at the Supreme Court Chamber's decision and the arguments that are being presented, there will be no other trial. Those who are being left out, willingly or unwillingly, knowingly or unknowingly, with or without their consent, or at least even knowledge, will not have their day in court. And that's why it is incumbent upon the trial chamber to make sure that before it does anything, that it is satisfied that everyone, all, receive their due process and justice in court. Justice for all or justice for none. With respect to your questions, on the first question, our position is rather clear. We have no particular concerns. We didn't draft it. I did point out what the prosecution noted in E124/2. This is the request for reconsideration, where in paragraph 25 they say the advanced age of the accused, given that the average life expectancy in Cambodia is 61 years, the advanced age of the accused is a critical factor in predicating whether a second trial will be possible. What were the OCP concerns when they were drafting the introductory submission? How could they have missed that point? And that's why I say to lay the blame on your footstep and to say, now you figure it out, at the same time satisfy us, is unfair. They drafted it. They asked that it be even expanded, knowing full well that the average expectancy is 61 years of age, and this is based on the World Health Organization. So it's not based on some inconsequential, unknowing NGO. And this is a 4 April 2001. You look at page footnote 42. So obviously, they weren't concerned then. Why are they concerned now? And why the rush? And why the disingenuousness in saying that if we only add S21, what has already been tried, then we need not go any further. That's representative. And what my colleague indicated, the Supreme Court does point out the possibilities of conflicts of interest of the judges and the need perhaps to have a second panel. That's also a consideration, and I think the comment should be taken with due consideration by the trial chamber, that simply adding that, or in fact by excluding that, perhaps there is no appearance. But if you add that alone is not sufficient, even by the prosecution's own submissions in their notice and their subsequent motion for reconsideration. Question number 2. Our position is rather clear, that the entire case should be tried. I think I would be repeating myself if I were to say anything further on that. I do note that our preference would be that Mr. Ng Sari have certainty that he's going to be tried once, that there will be one trial. While it may be a factor, it may be a consideration, it may be something that we all should keep in mind, all meaning excluding us, because we were invited here, so we're here, as to whether our clients will be able to follow the proceedings or be alive so that there is a resolution. I think that were the trial chamber to take a pause and look at the remainder of the closing order, I am certain that with some creative thinking, it can reduce the scope of the witnesses. And the system does provide for the admission of evidence for you to try the entire case. Obviously, it would prolong it by 6 months, maybe a year, but the prosecution is willing to risk it. At least prolonging it by a month, in for a penny, in for a pound. If they're willing to risk it, why not try the entire closing order once and for all. It provides certainty. It will certainly eliminate the constant procedural battles that go on in this courtroom where we're trying to decide, is this within the limits, the scope, or is it out? It certainly allows the defense the opportunity to know exactly who are the witnesses. And since the Supreme Court seems to be suggesting that this is an adversarial proceeding in the sense that I understand adversarial, the prosecution needs to point out, since they have the burden of proof, what are the actual witnesses and evidence they need to produce in order to prove their case, the closing order, which they are essentially the author of. So the onus shouldn't be on the trial chamber. The onus should be on the prosecution, if we are to believe what the Supreme Court chamber says, because they make it very clear that this is sui generis, a term that is often used in order to justify importing procedures from foreign jurisdictions which may or may not necessarily be consistent with the proceedings. But there's nothing to prevent the trial chamber from ordering the prosecution, and in fact we are suggesting that you order them to come up with a list of witnesses and documents that they believe will prove their case for the entire closing order. At least, at the very minimum, we will know for certainty who and what documents and what civil parties are not going to be represented. Who are they willing to throw, to cast away for maybe some other proceeding, which everybody admits will not occur. Question number 3. Again, we've indicated that we want the entire case tried, not some portion of it, not justice a la carte, not where you pick and choose. We believe that the trial chamber had it right initially. We knew and recognized that there were some logistical problems. But now the prosecution points to us and tells us it's impossible, okay, unless you have some sort of a plan. And as I've indicated, that plan will still be needed for another case. Otherwise, you are effectively violating what the Supreme Court has already told us, which is you cannot abandon or set aside or dismiss counts. And you can't just keep them out there in the stratosphere saying, well, we just parked them. We'll get to them when we get to them. They still exist. Question number 4. Now, maybe I'm reading too much into it, but when I read your question, you seem to be suggesting that what is being proposed by the prosecution, that is merely S-21, certainly, or not necessarily, meets the criteria of reasonable representativeness. That's a reading that I see. Maybe I'm overreaching. But I think we've answered the question that certainly what is being proposed by the prosecution is by no means representative of the closing order. We have pointed out that the prosecution has taken at least 3 different positions, starting with the notice and the motion for reconsideration. And in the motion for reconsideration, they point out what would be more as opposed to reasonably representative. And if you look at what would be more, is a lot more than what they're asking now. And more civil parties would not be abandoned. So, and as I've indicated also, it is up for you, Your Honors, to decide. And then, of course, the parties will decide, including civil parties, whether they are satisfied with what you come up with, reasonably representative, sufficiently satisfies this definition, which seems to be like a moving target. Question number 5. Okay, we already discussed that. Okay. I concur with my colleague that certain witnesses will have to come back and give evidence. I think that's unavoidable. We submit that since this is an adversarial proceeding, it is for the prosecution to inform the chamber what evidence it wishes to put forward. We don't have that onus. We also think that everybody should be rescheduled. In other words, no evidence be heard. None. Zero. Until we have finality on this issue. This is a matter that's normally dealt with at the pretrial basis. As I've indicated in my response to the appeal, to the prosecution appeal, which I thought was untimely, that the moment that they weren't satisfied with your decision on the motion for reconsideration, the prosecution should have moved and appealed at that stage. That might have been more timely. The Supreme Court saw it differently as one continuum. Perhaps they are right, which is why I say the Supreme Court, in a rather gratuitous fashion, said that there was a paucity of reasoning. Because if it's one continuum, then obviously all of your reasoning, starting with the very beginning all the way to the impugned decision, counts. And we submit that sufficient reasoning was provided by the trial chamber. Question 7. In theory, at the conclusion of 002/01, we could proceed, in theory. Of course, we would need to see exactly what plan that the trial chamber has in mind. When I look at this, and based on my 30 years plus experience and how you severed, because you've not dismissed, but merely severed, and if this is a continuation of one trial, only we're doing it in segments, okay? In my humble opinion, and some of my colleagues may disagree, nothing prevents the trial chamber from giving the parties some respite to regroup and to begin immediately with the other segments, because it's one closing order. There lies the difference. And so I think it is, in theory, possible. There are complications, and I think the prosecution has pointed out some realistic complications that need to be considered. But I think that all parties would have to see what the plan is, how you envisage, but also, I mean, there is also the realistic possibility that there will not be any funding. But that's something that cannot be taken into consideration. No more, as I would say, you should consider whether my client will be alive, and therefore we have to quickly make sure that he's found guilty. They wanted the closing order that big. They wanted to have all these. They claim all these crimes were committed. They claim all these people are victims. They claim that there were forced marriages, that there was enslavement, that there were all these. They have to prove it. Not for us to decide. Question 8. The way I read the question, again, I'm trying to read it as a lawyer. Which doesn't mean that I always get it right. But it seems to me that you're asking if we have been prejudiced by this uncertainty. Well, if the answer is, have I been prejudiced in the manner in which I've been trying the case thus far, the answer is no. I haven't suffered from any anticipatory anxiety, to be honest. No angst on my part, in a sense that you've indicated these are the witnesses, this is what we're trying, and we prepare as we go along. So I haven't lost any sleep. No need for tranquilizers to keep my heart still as to what will happen in 002/01. We've been proceeding as we would normally proceed. That doesn't mean that others have not been prejudiced. The prosecution has indicated that it does affect the manner in which they present their case, and we take them at their word. But have we been prejudiced at all? No. But again, will we be prejudiced down the road? That's a separate question, because that depends on how you formulate the plan. And to that extent, if I could, with all due respect, provide my observations on that, the trial chamber would have been better off if it had first heard the parties to see whether severance would be appropriate and to what extent, and second of all, come up with some sort of at least a boilerplate plan in advance, so at least we could provide our input and think about it as we go along. But those are my comments on that. As far as the annulment, we believe, we submit that the annulment of the severance order will actually result in a more expeditious trial in a more expeditious way of going forward on the entirety of 002. It brings certainty. There are fewer procedural disputes in court. The prosecutor will know exactly what it needs. And might I add here one observation on this. It might be useful, I don't know. At the ICTY, the prosecution is very independent. And the judges certainly can only do so much to cajole the prosecution. Even with Rule 73 bis D, you can see the trial chamber does not have carte blanche to do what it wishes. That would be ultra vires. That would be against the statute. But the trial chambers have, in many instances, determined the amount of time the prosecution will have in trying its case. So let me give you an example. In the Perlich case, which took 5 years to try, I'm a victim of that trial. Victim in the sense that I was representing one of the accused. 2 years later, was still waiting for the decision, the judgment. Initially, the judges had offered the prosecution 400 hours, actual hours, with a counter in presenting their case. 400 hours. And I can provide the transcripts if necessary. In 6 months or 8 months into the trial, one Monday morning we came in, or Monday afternoon, because we always had court on the afternoon on Mondays. The judges said, by the way, we've decided, no hearing, we've decided to slash to 300 hours. In other words, 25% of the time allocated to the prosecution's case was taken away. And then they said, by the way, if you want to be heard, we'll hear you. And then after we were heard, they took 7 more hours away from the prosecution, but then said, if you need additional hours towards the end, justify it, and we'll give it to you. Now, why am I saying all of this? I'm saying this because at the ICTY, based on that procedure, you have 73B bis dis as a mechanism to encourage the prosecution to cut away parts of the indictment. But the judges cannot force. So they have the power, but you have the discretion on running the court. And so the way to work this out is for the court to say, fine, if you want to try this entire indictment, this convoluted, complex case which you put together, that's your business. We're saying cut. You don't want to cut? That's fine. And this is based on Madame Del Ponte's approach. No justice a la carte. But they're saying, I'm in control of the courtroom. I'm entitled to control the flow of the evidence and the tempo of the trial. So you maintain your position, but we're going to put you through the paces. We're going to decide how much time you will actually have to try your case. And then, hopefully, you will have to make some decisions. Either do a little bit of everything and hope that you accomplish what you want, or reduce the indictment to something that is manageable and triable so that the case is not prolonged. And the point that I'm trying to make, Your Honors, is the onus is on the prosecution. They came up with this closing order. Let them come up with a plan on how to try the entire closing order at this stage. Concurrently, you can work on whatever plans that you may have. You want to work on a plan for option 1 or option or option 2. Either way, you're going to have to come up with plans. But the easiest way is to take the path of least resistance. The path of least resistance which maximizes justice for all. And that is to have a targeted trial for the entire closing order. And it is the prosecution who have risked the prolongation of this case by appealing Your Honor's reasonable approach in trying to manage this unmanageable closing order which they drafted, knowing full well the age of the accused and knowing full well that the average lifespan in Cambodia is 61, and my client at least has surpassed the average by at least 20 years. And when you're considering the lifestyle, the years in the jungle, and everything else, it's virtually a miracle that he's still here. But nonetheless, they went forward and they drafted it. These are our submissions, Your Honor. We hope that we have been helpful.
The President, thank you, Counsel. But as far as I understand, it appears that you have failed to answer question 6. You should advise the Chamber concerning the request by the co-prosecutor to expand the scope of case 002/01 as per their submission yesterday. Please advise the court whether or not your team has prepared the list of witnesses concerning this new issue, and if any, how many witnesses do you expect to hear, and when you can submit this list of witnesses, because this will form the basis for the Chamber to decide concerning the possibility of including these witnesses or to defer these witnesses also. We have to factor the time into our consideration as a consequence of this request for the expansion of the scope.
Thank you, Mr. President. Perhaps I skipped over that. Basically, let me be very clear. We're not proposing any new witnesses, any new evidence. It is not for us, it's for the prosecution. So whatever the prosecution says, we accept them at their word, but that does not mean that after we proceed as we go along, we may not make other observations. But as far as us making proposals at this point in time, since it's adversarial, we're not prepared to make any submissions on that, because our starting position is we believe now that the severance order has been annulled that you try the entire case. That is our position, and I believe my colleague indicated the pitfalls of just going on with the 405 witnesses that the prosecution has indicated. And given the complexity of the issue, certainly it will take more time, but be it as it may, we have no intention in this adversarial setting, as we've been now informed by the Supreme Court, of putting forward what we believe are any witnesses that need to be heard. Thank you.
The President, thank you. The Chamber now hands over the floor to the defense team for Mr. Kyew Sampon. You may proceed.
Merci, Monsieur le Président.
Thank you, Mr. President. I'll try not to come back over points which have already been covered by my learned colleagues in cases where I concur with them. However, the conclusions I reach are not identical to those of my colleagues on the defense about what we ought to be doing. And if I have not arrived at the same conclusions, it is because I believe it can be said here that we are not, Mr. Kyew Sampon is not in the same position as the other accused. I'm referring here to your first question, which concerns the state of health of the accused. You seem to wish to do some kind of package deal on this question, medically speaking, but the answer is no. Mr. Kyosampan is not going to die. Yes, Mr. Kyosampan is fit to stand trial. Notwithstanding the last few days of hospitalization, which he had not requested himself, Mr. Kyosampan is in fairly good health. As much, in any case, as you might expect for a man aged 82 who is kept incarcerated in 10 square meters for 5 years and 2 months without receiving a judgment. And while the perspectives of such a judgment occurring do seem to be growing ever more distant. The second point that I would like to make by way of an introduction is that Mr. Kyosampan, who is here in front of you all, not only is he in good health and fit to stand trial, but he has every interest in being tried as quickly as possible. He is pleading for acquittal from the totality of the closing order, and the sooner he is therefore tried, the quicker will he be acquitted. And therefore the sooner can he go back to his wife and children to live the remainder of his life with them in peace. Now, the fact is that you, first and foremost, Your Honours, and the prosecution and the civil party bench as well, are telling us time is short. The accused are going to die. They won't be fit to be tried. We won't have time to judge them. And since you're in such a hurry, you're telling us that you're going to be judging us several times over. However, that does not concern us. The decision simply does not tally with the position of Mr. Kyosampan. And as far as he is concerned, whether Mr. Kyosampan is concerned, whether you choose option 1, as described by the prosecutor, involving a succession of mini-trials in the interests of justice, or whether you opt for choice number 2, which would consist of a first trial that is more representative of the whole, so that the other accused could be quickly judged. One or the other, for Mr. Kyosampan, the position is the same. He is younger. He is the person whose health has made it possible to attend 90% of your hearings morning and afternoon over the last year and a half. And if you wish to make a slightly odd comparison, he is very much exposed in the shop window, so to speak. He is the only one who sits down on the accused bench morning and afternoon, day in and day out. And this repeats itself and repeats itself. And so if you, in the decision that we will be receiving from you, opt for a series of mini-trials, well, there are rules, as quoted by the prosecution, who referred to the Supreme Court and mentioned also by my colleague, Mr. Koppe, which need to be observed, because our client is concerned in both cases, option 1 or option 2. Either way, the situation is the same. He's going to survive. He's going to be alive. And he is entitled today, whatever ultimate option is proposed to you, which does not directly concern us, he has the right to know how you intend to judge him. Whether you set up a series of mini-trials because you believe that serves the interests of justice, and then you explain to us as well how you're going to solve the juridical and material problems that that poses. Our colleagues have already gone into that. Or whether, on the other hand, you decide to comply with the prosecution's arguments to add a site to this trial, which has lasted for 1.5 years, and which seems to fit itself into all sorts of shapes so that it may become, so to speak, more representative as a trial. And there I would endorse what my friend Mr. Koppe said. And bearing in mind what my colleague Mr. Carnivus said at the hearing on Monday, and the fact that when your chamber drafted its severance order in September 2011, if it is possible and if the accused survive, then they will be judged for the remainder of the closing order. Now, in both cases, the person who is going to survive among the accused persons is called Kyo Sompong, because he's in good health, because he's attended 90% of the hearings, and because he is fit to stand trial, and because he is asking to be tried, and he is asking for his acquittal. And he's been waiting for that for 5 years and 2 months. And hearing the arguments that were batted back and forth on Monday, and looking at all the documents that have been exchanged between the parties on this question, I have to say that optimism about reasonable timelines within which Mr. Kyo Sompong can be tried as he requests is not very high. Even if you go along with the combined appreciation of the prosecution that told us on Monday that they were envisaging an end of the hearings, evidentiary hearings in 2013, when will we reach the end of the evidentiary hearings, whatever decision you take? At the end of 2013? At the start of 2014? I haven't a clue. if the decision you hand down is not considered suitable by the different parties, there may be problems. Judge Friends, perhaps not intending to support my request today, nevertheless reminded us on Monday what the timelines involved in the Duik case, in which there was one single accused who accepted the facts and which entailed one crime site. The Chamber took 8 months to draft its judgment, and the Supreme Court Chamber took a year and a half to hand down a verdict, which is the final decision on Duik. Now, everybody, despite everything, agrees, and even the Chamber and the prosecution agree, that you can't really seriously talk about studying evidence in a 002 second stage trial while the foundation of 0021 is proposed to be used for subsequent trials, because doing such a thing would violate the rights of the defense and of all of the parties for that matter, and that is why, on the other side of this room, my learned colleagues have made that point. So, if we base ourselves on what happened in trial number 1, 8 months for a verdict, and it is easy to imagine how much time your chamber will need to draft a verdict in a much more complex affair. And if you bear in mind the time taken by the Supreme Court to hand down its verdict in the Duik case, which was a year and a half, then you have over 2 years plus a year of hearings. So we're talking about a low estimate of 3 years, bearing in mind the complexity of this trial. We will need at least 3 years, for Mr. Kersompan to receive justice. And when you have been detained for a long time and you are aged 82 and you're presumed innocent, that is really quite a considerable length of time. So I frankly would like to say that here and now, the fine words in favor of severance that will accelerate the procedure are totally imaginary, fantastical, because in point of fact, the result, as far as we're concerned, is the precise opposite. Whatever you decide, we will be prejudiced. Whether you opt for mini trials in the interests of justice, or whether you go for something that is more representative, and even if you opt for the solution which my colleague suggested, which is to judge the entire closing order, we are still prejudiced. And that is why I can say that, contrary to what has been said in this courtroom, the severance order did not protect the rights of Mr. Kersompan to a trial within a reasonable time limit. Your severance in fact, excessively lengthened the procedure, and now there is very little at your disposal to make up for what happened in that respect. Even as my colleagues are asking, you did decide to have a trial on the entire closing order, which I agree would have been the best thing to do at the outset, rather than severing. It would have been the most expeditious solution, but the consequences of such a choice would have been so important in terms of the time needed to deal with the arguments and contestations that would have been raised here and there, would have been so considerable that the prejudice for Mr. Kyo-Sampong would not have been any less. It comes to the same thing as it does here with options 1 or 2. And there's another thing I should draw to your attention, Your Honours, as regards the outcome of uncertainty in which we seem to be caught from the very start of this trial. Ever since this trial began, and this is precisely what the Supreme Court has criticized, we have been caught in a state of uncertainty. The dimensions of our trial are variable, and we don't really know what we are being tried for. Over the last year and a half, as the Supreme Court said very accurately, you have left, in your various decisions about severance, the doors perpetually open, and that is why the Supreme Court decided to declare the prosecutor's recent appeal admissible, because you never took a final decision about the scope of the trial until the day when, through a memorandum, now, rather late in the day, we are allowed to discover that there have been certain decisions taken, and through the appeal we discover certain things, and we are now told, that's it, stop. Herein you will find the definition of the trial. But frankly, it's a little bit late in the day, and the Supreme Court pointed this out in its decision, and that's why the prosecution's appeal was considered admissible. But when the rules change from one day to the next and are never firmly and clearly defined by the bench, then what does the accused person do, who doesn't know on what basis he's going to be tried? Oh, you can say that there's the closing order, and he was perfectly well aware that that closing order was there. But the fact does remain that we do not know, and we still do not know, what the scope of the trial is. And obviously this is harmful to our cause, but I would also like to point out that the situation has also had an influence on the decision that we took to remain silent. And somewhere along the line, this is not acceptable. You have to accept that by not strictly defining the boundaries of the trial and what you are judging Mr. Kyo-Sampong for, you are encouraging him to keep silent, because he's uncertain about what to expect. And, among other consequences of the present situation, I could also quote the fact that in the interests of speed, although we're not actually concerned by the need for expeditiousness, and that my client is fit to stand trial and attends all of your hearings, you have contributed, as I see it, to gagging the accused and the accused's defense team, because how otherwise can one interpret your completely unrealistic requirement not only to ask us right in the middle of a trial to submit a final memorandum on applicable law, but then what's going to happen to that if you change the scope of the trial? We'll have to come back and revise it. Not only that, but also you tell us, again in the interests of expeditiousness, that the final submissions of the defense should be limited to 100 pages. 100 pages of a final submission covering so far about 50 witnesses, maybe another 50, some 5,000 documents, and then 100 pages. That's some sort of bicycle thieves piece of paper. I'm sorry, but it's just a joke. It's ludicrous. You can't expect the defense to put its thoughts on such a complicated trial on 100 pages of paper, and I'm absolutely certain that you're preparing to go even further than that. In other words, to restrict our pleading time in court. I'm absolutely sure we haven't got there yet, but we are coming very, very close, I can tell you. We're going to suddenly be told, oh, the defense is going to have 3 hours to plead. Today we are being asked to take positions on options 1 or 2. What we are much more interested in seeing is rules that are permanent rather than fluctuating. It's not up to us to tap the hourglass and make forecasts week by week as we go along. We want a clear timetable that is respected. We want our rights to be respected.
President, the Chamber has outlined very clearly to the parties as to what subject matters are supposed to be dealt with. We ask the parties to discuss the implication as a consequence of the decision of the Supreme Court Chamber invalidating the impugned decision on the severance of K002. The Chamber is now intending to listen to the various comments and views of the parties in respect of this decision. In particular, the Chamber advised the party to look at the paragraph 50 of the decision that the Chamber advised the party specifically the purpose of this Chamber, so that the Chamber will have the basis for consideration in as to how the Chamber will proceed in respect of the decision of the Supreme Court Chamber. You are now deviating away from the intended purpose of today's hearing as required by the Chamber for all the parties to express their views in respect of this matter before the Chamber. The Chamber advised you to review the agenda and the subject of the hearing that the Chamber has communicated to all the parties. The Chamber wishes to gather all the views from the parties so that it has the basis to issue a new decision in respect of the decision of the Supreme Court Chamber. The parties are not supposed to raise any other issue out of the items of agendas the Chamber has decided. And if you have any basis for any other observation on any other matters, then you may submit to the chamber. The chamber will probably allocate other times for the purpose. But today's hearing is meant to address certain matters that the chamber have clearly communicated to the parties. We want to hear views from the parties so that we will have the basis for the decision as the result of our consideration of all views of parties in our basis, so that we can decide on the scope of case 002 in the future.
Oui, Monsieur le Président.
Yes, Mr. President. It is our view that at this precise moment,
President, if you understand the instruction, please compose yourself and try to be prepared for your submission so that you respond specifically to the question asked by the chamber. Otherwise, your response will not address the issues that has been raised by the chamber. So we ask you to revise your proposition, and you may submit your points again this afternoon. The time is now appropriate for lunch adjournment. The chamber will adjourn now and resume this afternoon from 1:30. Security guards are now instructed to bring Mr. Kyu Sampon down to the holding cell downstairs and have him back to this courtroom before 1:30. The court is now adjourned.